and see what was going on.
Okay.
I may have had a different understanding from that, if it's the same email chain that Ms. Nelson's referring to.
Okay, and it may be that Dr. Giroux did her job because we've got Mr. Lowe here. That's not the notation that I've got, but that doesn't mean that's not how it's working.
Your Honor, if I may, my name is Dr. Vargas. Again, I'm a psychologist that works here on the security unit in the hospital. My understanding was Dr. She's my supervisor, and she was meant to just facilitate the video call. She was a little tied up this morning and informed me during grand rounds about half hour ago, just to make sure that Mr. Lowe was present for his video hearing. So I explained to the council that if there's any specific questions, I can definitely reach out to Mr. Lowe's treatment team so they can provide those answers. But we wanted to make sure he was at least here on time and present.
Perfect. Well, why don't we do Mr. Lowe first? So the folks just sit tight. Mr. Franklin, you've taken over for Ms. Korean on this matter?
For Ms. Korean, Ms. Walsh, and a couple other people who've touched the case at some point in time, yes, sir.
Okay, well, most recently, Ms. Korean. I looked at the docket last night, and I printed out the indictment so that we could know exactly how old this is. So this is an alleged aggravated assault from 2007. It's alleged that Mr. Lowe committed an assault with a glass mug. And Mr. Lowe has been under indictment now for 13 years and 12 days.
Yeah, I believe there's a second case that we all had paid attention to more so. It should be after that on the calendar.
It's not on the calendar. The only one on the calendar is so what's the other case?
10 SC, good morning, Judge Adrian Love, 10 SC 92615.
Yeah. I'm looking at my calendar. It's position 7. It's on a page by itself, so maybe it didn't print.
Okay, it's on the back side. I didn't see that. Oh my, that's a very different charge. Okay.
Yeah, so that's the reason why things have drug on for so long. And that's
got it. I'm now more at peace with the situation because this aggravated assault seemed like a borderline aggravated assault. But the 10 SC case explains why Ms. Love is here and why Mr. Lowe is still working with us on this. So what is your understanding, Mr. Franklin, of where Mr. Lowe is in the stabilization process?
My understanding is that Mr. Lowe has been deemed competent at this point in time.
Okay.
I came into the case, Ms. Korean's name was on it, but the person who I talked to and personally inherited it from was Ms. Walsh about a little over a year ago. And because we had concerns at that point in time regarding the finding of competency. To give a brief version of the history, throughout the many years since the indictment, there had been periods of time where Mr. Lowe had been deemed competent and decompensated. I think that was largely caused by him being taken from Georgia Regional to Rice Street, where he would then decompensate and then he would go back. So I think the medical and clinical staff at the hospital have done the best thing, which is upon deeming him competent, just keeping him with them so he doesn't decompensate. Our question from our end more so though is, as opposed to being able to kind of understand the process and those, I'm gonna call them the basic questions that are kind of the framework for determining competency. Ms. Walsh and myself had concerns about his ability to assist counsel during trial. So that's when we were. I dealt with Adam and Body prior to Ms. Love getting in the case. I let her know that he and I had some conversations. The last time I believe we were in court, I think I let you know that we were hopefully we were requesting a NGRI. That's kind of what Mr. Lowe has been schooled up on and what we are working towards. Under the prior administration, that was a no. And we wanted to wait until the new administration got in under Ms. Willis and kind of see if we were able to have a different conversation. I spoke with Mr. Abadi maybe about 3 weeks ago at this point in time, or maybe 2 weeks ago. And he informed me that the state's position is still going to be guilty. They would consider a guilty, but mentally ill plea. So I think we were at an impasse at pre-trial discussions in terms of resolving things, and given our position on his ability to actually assist during trial, then we will probably have questions about his competency in terms of actually trying the case.
So what's the next step? I have, Ms. Lowe and I, in a different case, have been through this process before. It sounds like at least one expert has determined that Mr. Lowe is competent to stand trial. And as I understand it, I'm not an expert in the area, that would include a finding that Mr. Lowe could assist counsel, not just that he understands what's going on, but that he could meaningfully assist you, Mr. Franklin, in defending the case and doing what you want to do on his behalf. I understand you and Ms. Walsh may have a different perspective on that. So are you planning on having a different expert evaluate Mr. Lowe on that dimension, or what are we doing next?
I mean, this is my first time dealing with this kind of case in this step, so I believe that's the next step. I honestly thought was hoping for a bit of guidance from the court. I hadn't dealt with this before,
Okay.
So I'm entirely positive.
So what typically happens in a scenario like this is that there will be dueling experts. It's dueling if there are different perspectives. But right now it sounds like there's an expert who's concluded that Mr. Lowe is competent. You're not so sure about that. You're certainly entitled to have your own, meaning an expert that your office retains, evaluate Mr. Lowe for competency. And then if that answer is different from what we got from DBHDD, the state is in a position to bring in its own, and ultimately the court can, although usually DBHDD serves as that neutral because it is the court that directs DBHDD or it could be Brady or Emory that performs the assessment. So I do think, but I'll hear from Ms. Love in a moment, that the right next step would be if you disagree or are uncomfortable with an assessment that indicates that Mr. Lowe is able to assist you during trial, be for your office to obtain your own expert to get a second opinion.
Right.
Ms. Wells, what are your thoughts about this situation?
Judge, Mr. Franklin and I spoke briefly about this matter before you came on, and the next step would be a competency trial. After the court set a date for a competency trial, I believe it would be in and I'll let him speak for himself, but I believe that he would want to get his expert to evaluate Mr. Lowe as close to that trial date as possible, because each expert is going to say he was competent at the time that I evaluated him. So in order that we keep the process moving, I believe the best step to next take would be to have a date set down, since the friend of the court has opined that he is competent, and Mr. Franklin, his assessment and interacting with, or his office's assessment is that he's not. He does not accept that opinion, and so he contests it. And so we need to, because the state is certainly willing to accept it. So at this point, we need to, even before we entertain NGRI or guilty but mentally ill, there has to be a finding by the court that he is not incompetent, so that we can proceed. Because at this point, given DBHDD's assessment, he's presumed competent. So at this point, we'd next have a trial. But like I said, I believe would want to have Mr. Franklin have his expert evaluate him as close to that date as possible.
Sure. So I think a few things need to happen. Thank you for that perspective, Ms. Lowe, I think a few things need to happen. One, and this is procedural, you, Mr. Franklin, out of file and entry of appearance, it's got Ms. Korean still. She has substitution of counsel back in 2016, just so that the docket is keeping up. But more fundamentally and more importantly, I think there are pleadings that you need to file that trigger the, now we need to have a competency trial. I don't see, but I'm only skimming the docket. It's focused on the ag assault, and it's going to be a very different conversation, right? Plus the state for why are we still around for this? But that's not where we are. But I don't know that I see anything in the docket for the 10SC case that indicates that the defense is challenging competency and thus is requesting a judicial determination. In other words, a trial on competency. There is, I think, way back in the docket, but it may actually have been in the ag assault case because they were sort of moving together. No, there it is. In 2011, there was a petition for an evaluation that Ms. Muti, this goes way back, that she filed on behalf of Mr. Lowe. And then the results were what the results were. Then Mr. Lowe came back because of some findings that some experts made. So if you would consult with your procedural experts in your office, Mr. Franklin, I don't know if that's Ms. Chabot or others who could give you, and you may already know it, I don't mean to suggest you need advice, but there are folks who know the right pleadings to file that bring to a head the issue of competency so that it's appropriate for me to set it down for a competency trial, where it really will be dueling experts, assuming there are experts that have an opinion that Mr. Lowe is not competent to stand trial. I do think I think Ms. Lowe's right, that's the next step, is to tee that up in the right way.
Yes, sir.
So what I will do is give you a couple weeks to look into that, and then maybe you can get back to Ms. Nelson and Ms. Lowe with what your plan is. That, yep, I know what I need to file, I'll get it filed within the week. It's not like filing a brief with the Court of Appeals or something. I think you just need to invoke the right statutory provisions, and then I can set a date. It just needs to be far enough out that you have time to enlist an expert if that's what you want to do. And of course, we either needs to be a bench trial or a jury trial. If we want a jury trial, we have to hold off on that a little bit, although I will tell you, no one has a larger number next to his name than Mr. Lowe in Fulton County, 3,988. So if Mr. Lowe and his lawyers were ready for a trial, he would be the very first in line. So is a couple weeks enough time, Mr. Franklin, for you just to touch base with your colleagues and let us know what you're going to do?
I had that conversation today. I thought that the maybe I did on a different case at another point in time. I thought I had filed a special plea, but I'll check in that, and I'll probably have those documents filed by the end of the week. So
great. Yeah. So the last thing filed, the last 4 things in the docket in this case are all court orders, and the most recent is from 2019, July 2019. Judge Reeder removed the case from judicial hold on July 8th, and nothing has happened with it. In the docket, nothing has happened with the case.
I got you.
I appreciate Ms. Nelson bringing this one back up. Mr. Lowe, can you hear me?
Just say that one more time.
Yes, sir.
We've been talking about your case a little bit. Your lawyers will be in touch with you about what's going on. I just want you to know we are going to start paying more attention to your situation, okay?
Yes, sir.
All right, thank you, Mr. Lowe.
Thank you.
All right, Mr. Franklin, we will look for something from you, and Ms. Lowe, this is your case now?
It is, Your Honor.
All right, well, welcome aboard.
Thank you, Judge.
And I think that addresses, so I guess position 6, the ag assault from '08, that's just sort of following along until we resolve the 10 SC case that's hanging out there.
That would make the most sense to me.
Correct.
I think it's still under judicial hold. I don't know if that needs to be lifted or not, but it's out there still.
Yeah, I think because it was the case, I forgot to flip over the page to see the final position. I think it enjoys the same status as the other case. No, for some reason yeah, so Mr. Franklin, you may want to look at that file as well, because in February of 2019, Judge Reeder entered an order in the ag assault case saying that Mr. Lowe had been deemed not competent, and so it is on judicial hold. So there are conflicting positions in the two dockets, and I don't know how in your office the files would be organized, but there may be findings in the '08 case that are germane to what is going to happen in the Tennessee case.
Sir?
All right.
Are we excused?
You are. I just needed to wrap that up. But we are. Thank you, Dr. Vargas, for getting Mr. Lowe online. Appreciate it.
Not at all, of course. And again, Mr. Franklin, if you have any, or if anybody else has any other questions moving forward, Dr. DeRue is a psychologist who's assigned to cover the case. We had a recent shakeup where one staff member left, so we're kind of scrambling to make sure everyone's addressed. But moving forward, Dr. DeRue will be the point of contact. And in the future, I might just facilitate a hearing, but anything else, just reach out to her first, and we'll do the best we can to help.
Yeah, absolutely. I have her contact information. Thank you.
Thank you, everybody. Bye.
Thank you. Your Honor, may I be excused? This is the only case that I have on your calendar.
Yes, ma'am.
Thank you.
All right. If we go back to the beginning of the calendar, our first position is Quadravius Berry. Ms. Nelson, is this these inmates are out of the jail or they are here?
They're at the jail.
Okay, great. Is that courtroom 3?
Yes, good morning, Judge.
Good morning. Are you Mr. Berry?
Yes, sir.
Good morning, Mr. Berry. Sorry to keep you waiting. We had a gentleman who was patching in from a different location, and a couple other folks were on for that one, so we need to take care of that one first. Who is handling Mr. Berry's case for Mr. Berry, Mr. Frank?
I am, Your Honor.
Thank you. All right, so this was on the calendar a couple months ago for a revocation. I've got the petition, which alleges a new criminal violation out of DeKalb and another one out of Fulton from a while ago. And then the probation could not find Mr. Berry in May of last year. What was the plan for today? Were we going to have an evidentiary hearing, or why did we bump it from January, if anyone remembers?
I'm not sure the reason for it being bumped before. Ms. Hall and I discussed it as just a brand new kind of situation.
Okay.
So if I can discuss it in that vein.
Sure.
Mr. Berry, the two offenses alleged in the petition, he has another another charge. He's currently in custody on a trafficking, I believe it's in heroin case. And based on the fact that that case will carry a mandatory minimum of some sort, and he has no bond on it, any revocation that we held would not be dispositive. Additionally, I believe, and I haven't been able to confirm this because I had a conversation with Mr. Berry last night, and I don't have access to Odyssey on my laptop. The DeKalb County case, I think he pled to that prior to this case. Like literally, he pled to it prior, but he didn't commit the Fulton County case allegedly until he committed that before he pled in DeKalb. So essentially, he is to have alleged to have committed both of those crimes and just pled to the Fulton one after the DeKalb one without having committed it after the DeKalb. So I don't believe it to be a violation of his probation because he didn't commit the crime before this one, if that makes sense.
I think so. Let me say it a different way if I'm understanding you. His plea in 19 SC, that's what he's on probation for. You're saying that plea occurred, you believe, after the commission, the alleged commission, the commission of the burglary in DeKalb.
The plea occurred, correct, but not the actual incident. Yeah.
Right, but if he wasn't, I'm looking up the.
That's what I was informed of, and because I didn't have access to a version of Odyssey that's working right now, I didn't have a chance to confirm it after last night.
So it's interesting. I guess we need to get a little more information because they happen almost impossibly close in time. Mr. Berry entered his plea in the 19 SC case, this aggravated assault, family violence aggravated assault, on the 13th of January of last year. It is alleged in the petition that he committed the burglary the very next day. Now, he got a sentence of 4 years probation in front of Judge Reeder. So if he had been in custody when he pled, he was released. If he had not been in custody, then he was out. But at least what it says in the petition, he violated probation the very first day he was on probation, or the next day after he was on probation. So it actually wouldn't play out that way. But to your point, this all seems kind of moot right now because Mr. Berry's not going anywhere with no bond on a heroin trafficking case, with an open probated case, and he has some sentence out of the cab as well. And there's no dispute that these trafficking allegations came after his ag assault plea and his burglary.
Correct.
Okay. So what was the plan? So setting aside, did this burglary happen the day after he got sentenced, or the day before? What's the plan? Is it just to defer this because he's stuck on the trafficking case?
Yeah, because he's stuck on the trafficking case, and more importantly, because he carries a mandatory minimum sentence that will control, and we're not dealing with a petition that deals with that. We think it would be more efficient if if we wait for him to deal with the indictment of that case, and this would likely just rerun concurrent to the more serious charge.
Got it. Okay. So, is there a hold on Mr. Berry because of this warrant?
Yes, there's a no bond on the CP case. There's the probation warrant, and then I believe there is another hold from a different jurisdiction.
Okay, but I just want to make sure if next week Mr. Berry got a bond in the heroin case, he's not going anywhere because we would have to work through this revocation first.
Correct.
Okay. Ms. Hall, I'm all right with that then. It's just taking, one answer would be prove up the burglary which he pled to. And it does sound like Ms. Nelson just shot me a message that he got released the day of this burglary. You can prove it up and we can have a revocation hearing. The question is that the best use of everyone's resources if he's got bigger fish to fry in the heroin case. And if Mr. Berry is not going to go anywhere before we work this out, I'm all right. Just leaving it as is. The state okay with that?
The state's fine with that, Your Honor.
Mr. Berry, do you follow what we've been talking about?
Yes.
Okay, so it sounds like the biggest issue we've got right now are these new charges from, I think it was October of last year. you're charged with having a gun and having a fair amount of heroin. That case has not been indicted yet, but the semi-good news for you is that there's grand juries running hard to get cases indicted, so that thing may move forward. Your lawyer on that case will probably work with you to wrap everything into one, including this revocation. But your lawyer right now, Mr. Franklin, has the good idea of just leaving this alone until you know more about what's happening with your heroin and gun case, okay?
Yes.
Any questions about that?
No, sir.
All right, thank you. Mr. Shipman is next.
Judge McBurney, that concludes my business for the day. May I be excused?
Yes, sir.
All right, thank you much.
See you.
So we got Shipman.
All right. Julian Shipman, how are you doing today?
I'm fine, Your Honor.
Good. Mr. Shipman, you are here because we have a petition to revoke your probation. There's an allegation that in December of last year, so about 4 months ago, you committed the crime of possessing a firearm, which, if true, would be a violation of your probation and the law. Ms. Patel, are you handling Mr. Shipman's case?
It's mine, Your Honor.
Oh, hello, Ms. Snyder.
Good morning, Judge.
Good morning. So what are we planning on doing with Mr. Shipman?
There is actually an amended petition that has two bases. One is a Fulton County case and one is a Bartow case. After speaking with Ms. Hall, it is my understanding the state intends to revoke the balance. So we would like to have this reset so I can get some of the stuff about the new case in Fulton and the stuff from Bibb County so I can have a better conversation with Mr. Shipman whether we should stipulate or go forward with a full hearing.
What is the balance of probation?
Judge Evans is 3 years, 4 months, and 25 days remaining. 3 years, 4 months, 25 days remaining.
Got it, thank you. Is it Bartow or Bibb?
This petition says Bartow.
Okay. I have the older petition, so I just have the, actually doesn't say where the gun charge is for. It doesn't say in the petition, it just says.
That's there was another petition that was filed. I think it's the one on top on Odyssey. Patel and I had this problem when we had our conversation, is her petition was different than the one I printed from Odyssey. So there's a gun charge from Bartow and then a gun charge and an aggravated assault in Fulton, which is what he's in Rice Street for, and he does not have a bond on that case.
Okay, here's a petition from just a few days ago. And I signed it. So there's the 1219, and that was the Bartow. Got it. So the older version of the petition doesn't say it's in Bartow. And then less than a month ago, there is the allegation of ag assault and a gun again here in Atlanta. And there's the 3 years. Okay. So the state is seeking a meaningful revocation. You want a little more time, Ms. Snyder, to look into the facts or whatever exists in the Bartow and the Fulton cases. And then, do we put it back on the calendar? I think rather than drag Mr. Shipman back into court for you to say, now we want a hearing, why don't you tell me how much time you would like to do your due diligence so that you, which would include then conferring with Mr. Shipman, so that you could let Ms. Nelson and Ms. Hall know, you know what, rather than have a hearing that is Asking for mercy, we're gonna have a hearing where the state needs to prove up the charges. That make sense?
Yes, sir. I would just ask Ms. Hall if she's been able to get the stuff from Bartow and then the police report from the 21 CP case.
No to the first question, yes to the second question. I have the police report for the CP case, but not the Bartow. So I get it. I get that to you.
You'll get Ms. Snyder the CP case information
Immediately, and then I'll reach out to Bartow.
Then you both should reach out to Bartow. I mean, just someone may get lucky and get it sooner. Should I have Ms. Nelson put a tickler in for a couple weeks, or what's a fair amount of time, Ms. Snyder? I'll get to you, Mr. Shipman. I'll wait for you in a minute, I promise. Ms. Snyder, you still there?
Yes, sir. Can you hear me?
Now I can.
I'm sorry, my internet's cutting in and out.
So how much time would you like to make sure you can get the information you need and then speak with Mr. Shipman to let Ms. Nelson and Ms. Hall know whether it should be a revocation hearing, i.e. bring on the evidence, or a more of a sentencing hearing?
A few weeks will be fine.
Okay, but is that 2 weeks or 3? You have the time you need. Just tell me what's the detail.
A month would be great.
Okay, so Ms. Nelson will poke you a little bit if we get to April 23rd and we haven't heard what's going on with Mr. Shipman. Now, Mr. Shipman, you had raised your hand. Is there something you want to add?
Yes, because I've been through this before. I was trying to see how can I be revoked if I didn't handle my case.
If you have not handled your case, or you want?
I haven't handled none of my case, so I don't get how I can be revoked on charges I haven't pleaded guilty to. Like,
Right, and I will explain all of that to you, Mr. Shipman.
but I have to wait on a whole nother court date, a whole nother month, and I got to be held in on probation on something that I can be proven innocent on.
So do you have a bond on your?
Oh, I'm supposed to be going to a bond hearing soon.
Okay, well, you can go to that, and if you get a bond in that case, then you and Ms. Snyder should talk, and it may be that we need to get together sooner. I'm not interested in holding you longer than we ought to be holding you, but I just want to clear one thing up. It may be that, let's pretend 2 weeks out, the state says, we're ready. We will have a mini trial here if you are choosing to challenge the petition, which is 100% your right to challenge it. We'd have a little trial, officers would show up, or whoever the witnesses would be, and the lower burden of proof, if the state proved that, I'm making it up, you had a gun in your waistband in Bartow County, I could find that you violated your probation. I'm not finding you guilty of the Bartow case. I'm finding that the state proved by a preponderance that you had a gun on you in Bartow County in December of last year. That would be a violation of your probation. And I could revoke your probation for as much as I felt was appropriate, even though you haven't resolved your Bartow case. And the same with the Fulton case. Before it gets indicted, we could still have this probation trial with witnesses. You have your lawyer here, et cetera. And if I found that you had broken the law in Fulton County, then even though they hadn't indicted you yet for that, that would be a basis to revoke your probation. So the fact that you haven't handled your cases is not an impediment to us doing a revocation hearing. The burden's on the state. They have to prove it up. And so you're saying you were innocent. You know, if the officer's testimony is there was a gun in a car, it was not Mr. Shipman's car, Mr. Shipman was in the back seat, the gun was in the glove box, then and it's registered to the driver, then you didn't violate your probation. And I don't know the facts, your lawyer's gonna learn the facts, the prosecutor's gonna learn the facts, and maybe people have a real different perspective on things. But until they can learn more about what the Bartow case is all about and what this much more recent Fulton County case is about, you're going to stick right where you are. I would be giving you a bond given these allegations. But it also sounds like you don't have a bond on your Fulton case. If you get one on these new charges, let Ms. Snyder know, because that may make us handle this in a totally different way, okay? All right, so Ms. Snyder, at the latest, let Ms. Nelson know by that date in April. The sooner you've got what you need, the sooner we can get this on a calendar for whatever we're going to do with the case. Again, it may be the state takes a real different view of it when they get the evidence as well. But that's what's going to guide us for now. Mr. Shipman, do you have any other questions?
No, sir.
Okay, thank you. Gets us to Mr. Pharrell or Pharrell?
Pharrell, sir.
Pharrell?
Yes, sir.
Okay. Good morning, Mr. Pharrell.
Good morning. How you doing, sir?
I'm doing okay. Ms. Snyder, is this your case also?
Yes.
That's my case, Judge Renee Rockwell.
Hey, Ms.
How you doing,
Rockwell.
Judge?
Good morning.
How you doing, man?
Good morning.
Good morning.
All right, so we've got everyone we need. The petition I have, assuming it's the latest version, has Mr. Pharrell allegedly violating his probation from a case from 2012 because he got caught with a gun, allegedly in some reckless conduct in March of last year, so about a year ago. I signed this petition in July of last year, and I guess more recently get caught up with Mr. Pharrell. So, Ms. Rockwell, is Mr. Pharrell admitting to this? Is he contesting it? What are we going to do today to move this case along?
So, Judge, we have been in communication and negotiation with Madam Prosecutor. The short story is, I don't know that he necessarily got caught with a gun. There was not a gun allegedly on the scene. What the state has indicated to me is the state does want to speak with the neighbors. The allegation is that there was a accidental discharge of a firearm that went through the wall and landed in the neighbor's unit. The allegation further states that Mr. Pharrell ran over there to make sure everybody was okay. I don't know that anybody was in the apartment at the time. The arrest was a good while ago. He made bond, and then he was arrested for the probation violation. What I would like, Judge, and I don't know if Your Honor would agree to this, is for us to handle this more like a failure to prosecute at this time. I would ask if the court would consider releasing him on a bond. He is he's been on probation since 2013. Is that right, Ms. Hall? If I misstate anything, please jump in. The underlying case has not yet been indicted. It is a Fulton County case, and he has been out on bond for that case. I don't know that the state objects to a bond at this time. He does have two children, a 12-year-old and a 6-year-old, and he's got 3 different jobs, 2 that are active and one that he's just getting together, up and coming, which is a food truck. And he's got his paperwork together. The name of that business is called Ghetto Burgers. So that's where we are, Judge. And I didn't know if this is something based on his long history, based on of not violating, And I always tell clients that we could have gotten you off of probation 8 years ago. That doesn't help me now or him now, but I do want the court to know that I don't know if the state's going to do a backflip and object to him being released on bond.
Well, I won't call it a backflip, I'll call it their reasoned opinion. I'm just looking things up here. There is this. All right, so Mr. Pharrell pled in 2013, June. He got 9 years of probation. So he ought to be pretty darn close to being done. And to your point, Ms. Rockwell, probably could have had it terminated under all these different laws that have been passed, encouraging folks who are doing well to get them off probation's books. But let me ask our probation expert here, Ms. Crawford, good morning.
1 year, 3 months.
Good morning, Judge.
2 questions. One is how much time remains, and then the second is what do your files tell you about how Mr. Pharrell has been doing on probation?
Okay, you went in and out a little bit. I can tell you he has 1 year and 3 months remaining on this case. Your second question, I didn't quite hear you.
Sure. The second question was how has Mr. Pharrell been doing on the 7 years and 9 months it's been on?
Okay, let me check just a moment. I didn't think I saw any violations, but I'll check.
I noticed one of his defendants got revoked for a year, but that's not Mr. Pharrell.
Mr. Pharrell has a year remaining, but I don't see, hold on. He hasn't had any violations on probation.
Okay.
Any violations?
Go ahead.
You were asking how has he been doing on probation?
Yes, ma'am.
Yes, he hasn't had any violations other than his new violation. He hadn't had any violations or any case notes that I see where he violated.
Okay, well, that's good. His co-defendants didn't do quite as well. One had his first offender revoked. Another got revoked for a whole year for catching new charges. So it sounds like Mr. Pharrell hasn't had any run-ins with anyone or anything until this situation in March of last year. Your thoughts, Ms. Hall, about how we ought to move forward with Mr. Pharrell?
Well, Your Honor, first, I think that the date is wrong on the petition. The incident happened December the 13th of 2019.
So it's even older?
Yes.
Okay, it says March of 2020. So you've got paperwork. Is there a CP number?
Yes, 19 CP 188496. What Ms. Renee Rockwell indicated to the court is correct. This was a discharge of a firearm that went into his neighbor's apartment. No one was in the home at the time. The resident was walking her dog. The residents did, or the victims did, confirm that Mr. Pharrell went over to make sure everyone was okay. He did tell the officers what happened when they arrived. He was arrested. He did receive a bond for this case. He was released 2 days after. This warrant came last year, and then he was picked up on it about 27 days ago.
What if, just as a crazy idea, given that this other case is stagnated, I don't know what the state's going to choose to do with it. If he got revoked 30 days, reduced the time served, and we move on.
I'm okay with that, Judge.
Ms. Rockwell, that way we don't have to come back and do more. Does that work for you and Mr. Pharrell?
That works, Judge.
Mr. Pharrell, if just based on these allegations, you're not admitting to anything, you're stipulating that you know these allegations were made and got arrested. If I revoked 30 days, but reduce that to the time you served, and then I reinstate you on probation, with all the conditions you had before. Is that something that works for you?
Yes, sir.
All right. You know, Ghetto Burger may be copyrighted. There was that little lady who sold, it was ranked best burger in America by some fancy magazine. Is she related to you? I think she may have passed, but you gotta make sure you don't get sideways with like the trademark police by taking over her name.
No, I know of her. No,
Okay, well, she set the bar pretty high. I never had one because apparently like, there were only like 3 seats at her little place where she did it. If you got there late, you weren't gonna eat. But they were supposedly pretty good. All right, so what I'm gonna do then, Mr. Pharrell, is in light of the fact that you did get arrested in December of 2019 for these charges, I will revoke 30 days of your probation. I will reduce that to the time you served and reinstate the balance of your probation. That will take care of this warrant and petition. If you don't get out today, you should be out tomorrow. If you have dinner at Rice Street tomorrow, call Ms. Rockwell and she'll reach out to me and we'll figure out why you're still there. But you ought to be out in the next 24 hours or so, okay?
yes, sir.
All right, good luck with your different businesses. Take care of your family.
Thank you, sir.
Judge, may I be excused?
Yes, ma'am.
Thank you so much. Good to see y'all. Stay safe.
Yeah, thank you.
I miss Renee.
So I don't have a petition for Mr. Buford, who's next, so.
Plea and arraignment.
Oh, it's plea and arraignment?
Yes.
Okay, it says probation revocation.
Ms. Nelson corrected it.
Oh, that, okay, she may have sent an email for that.
Yes.
It's a case that was in non-complex and was re-indicted, and then went into judicial hold, and he just got picked back up.
Okay, so does he have a second case, or he's just got this?
There is a 20 CP.
Okay, I see that there, so that is hanging out there, but we've got this old 17 SC case, which is on for, okay. Good morning, Mr. Buford, how are you?
I'm great. Good morning, sir.
I'm Judge McBurney. I'm just looking up your case here on my little screen, see what's going on.
Okay.
Okay, yeah, let's say probation revocation, but it is not that. Let's see why it transferred. The facts do not fit non-complex. That's not allowed anymore, by the way. You guys ever hit finish that there.
Oh, wow.
Julie, it's not, they keep putting it in the orders.
Well, but they can't just check that box. They have to specify what the situation is. I don't see, I mean, this is our case now. We'll own it, we'll move it, but I don't understand from looking at the indictment in this case, why. You can, in just a second. I want to hear from your lawyer first, but I promise, Mr. Buford, we'll give you a chance to talk as well. I also want to look up your new unindicted charges as well.
Oh.
That's a more complicated case. Okay. She got a bond. Oh, way back in March. Okay. So, Ms. Snyder, why is Mr. Buford in jail?
It was on a plea and arraignment calendar earlier this year, but due to the age of the case, I didn't have any contact information for him. And I don't, and then Your Honor.
So it's a bench warrant. Okay, got it. Now I'm following it. Because Mr. Buford has a bond, this 20 CP case, he's had a bond since March of last year. And it's a where there were signature bonds. It was a signature bond. So presumably he got out on that one. Okay, so we need to do plea and arraignment and sort out whether Mr. Buford ought to be put back out on bond in the 17 SC case as well. Is Mr. Buford wanting to be formally arraigned, or is he waiving arraignment, Ms. Snyder?
I will waive arraignment.
Okay, you'll fill out that paperwork?
Yes, sir.
Okay. Do you have a good address for Mr. Buford, or do we need to get that from him right now?
If we could just confirm with him that his address on Odyssey is his appropriate address.
Sure. So, Mr. Buford, I'm looking in the system here at where we would find you, and it lists as an address Kenridge Parkway in Decatur. Is that your spot?
Yes, sir. 2700.
And what is that? Is that a house or an apartment?
An apartment, sir.
Okay. There's no apartment number though. It just says 2700. What apartment?
It's 2700.
That's the apartment number?
Yes, sir.
Okay. And who lives there with you?
My mom.
Okay. So she's there right now, or at least she's living there right now.
Yes, sir.
Okay. And if I were to send you something to that address, 2700 Kenridge Parkway, that will get to you and your mom. I don't need to then say apartment B7 or something like that.
Yes, sir.
Okay. Do you have a phone number that Ms. Snyder could use to contact you?
To contact me, I do.
What's that?
It's 470 370 9368.
Did you get that, Ms. Snyder?
Yes, sir. Thank you.
Great. Ms. Snyder, do you want to give Mr. Buford any contact information? Well, he can't write anything down right now, but do you have a way of reaching him?
Yeah, I'm going to go to the jail later this week.
Okay. Well, maybe out. We'll see. Mr. Buford, that cell phone is where?
It is in the possession at College Park. Where I was arrested at.
Okay. So
has the phone.
Okay. So you need to go there and get it?
Yes, sir.
Okay. So that's not a great phone number for you right now.
Not for me to use today, no. But as soon as I get out, like what's going on? Like, cause I'm under the impression that I want to be released. And this is
let me ask a couple more questions, and then we'll figure out what's going on. Do you have a phone number for your mom?
I do.
What's that?
404-615-3000.
404-615-3000?
Yes, sir.
Fantastic. All right. You get that, Ms. Snyder?
Can I give you her house phone number too, just in case she don't answer?
Sure.
It's the older lady, so she might not hear her phone or something.
Sure.
It's 404-883-2040.
And whose number is that?
Her house number.
House phone number.
His mom's house number.
Oh, house number, as opposed to cell. Got it. Okay. Excellent. It's just good to have ways to reach you, Mr. Buford. So, let's figure out what's going on with your old case. So it looks like in March of 2020, Mr. Buford was reinstated on his original bond in his case got reindicted. So there was an older 17 SC case. It got reindicted, and the new indictment landed in non-complex, or it was not complex. And a judge entered an order reinstating his bond from the old case. My thought would be to reinstate that bond yet again, it's sort of a tattered old bond, unless the state objects to that. I don't get the sense that Mr. Buford was hiding from us. I get the sense that a robo case had a little trouble catching up to it.
I have no objection, John.
Okay. Any issues with that, Ms. Snyder?
No, sir.
So, Mr. Buford, you have a bond on a case of yours that is not indicted. It's an ag stocking case. You got a $10,000 signature bond last year at some point. We're not here to talk about that case. If that does get indicted, it's going to come to my courtroom because your older case is here and new cases follow old cases. But your older case from 2017 that charges you with cocaine and marijuana and having a gun, that's the one that we are focused on now. And you had a bond, let's see if I can find that bond.
I actually, Ms. Rockwell was here on that case. I had Ms. Rockwell handle the case for me, and I was here. I went to court here, and to my understanding, that the case got dismissed. I think I got out on July the 15th that year. My birthday is July the 14th. I got out the next day, and as I was reading on the internet, I think it got picked back up on the 21st, which I don't understand because the police didn't have a search warrant at the time. That's why the case got dismissed.
Okay, but so we're not going to dive into the facts of the case. Ms. Snyder will connect with you on that. But you're right, July 21st, it did get reindicted. Let me look at the old version of the case. It was dismissed by the state on the 12th of July 12th, 2017. But then the case, the state reindicted it. I don't know why. This is not my business, and I bet poor Ms. Hall doesn't know why either right now. But she'll need to figure it out. But either way, you've got this newer version of the case that is sitting out there, and you're going to need to work through it with Ms. Snyder. You're free to hire a lawyer if you want to hire a lawyer, but Ms. Snyder has been appointed to represent you unless and until you bring someone on board. Ms. Rockwell's name does not appear in the file for the one that got dismissed. There's someone named Rachel Berman who's listed as your lawyer, but that's all, it doesn't matter. That case is gone. But there is a newer version of it. It looks like almost all the same charges. And like I said, that re-indictment was handed down on the 21st of July of 2017. And then nothing really happened with it. You didn't show up for court. I don't know if you knew to come to court, but you didn't in August of 2017. And I think you got scooped up. When you got arrested on this aggravated stalking case, that bench warrant got dealt with, and then it got set aside, and a judge gave you back the bonds you had in the case that you described as being dismissed. It might be cleaner if we just set a bond in this 17 SC case. Given that the other one was dismissed, I don't know how valid that bond is, but I am comfortable setting an unsecured judicial release bond, which is the new term. Although I gotta make sure I can. There may be a bail prohibited offense on it. All right, so there it is. So I have to make it a little bit. Anyway, Ms. Snyder, if we set a bond for Mr. Buford in the 17 SC case, took it out, he already has a bond in the unindicted ag stalking case, whatever the charges are, in the 20 CV case, we'll move forward that way. We'll get a scheduling order out, Is there anything else we need to do for Mr. Buford?
Yes, sir.
Ms. Hall, do you want to be heard in opposition to setting a bond for Mr. Buford in the 17 SC case?
No, Your Honor.
Okay. All right. I'll get with Ms. Nelson on that. Mr. Buford, I'll get a bond order entered today in this old case. You already have a bond in your unindicted case. So once you post the bond in your older case, you'll be able to get out, get back to your mom. Were you working?
Yes, sir.
What do you do?
I do a lot of stuff, sir.
What does that mean?
Recently I've been working at a warehouse, FedEx, through temp service. I've been painting with my uncle, and I just recently got hired at this restaurant for doing the dispatch. I got hired that Saturday. No, I was gonna get hired that Sunday. I spoke with the manager Saturday, filled out the application, told me to come in Sunday for the interview, and I spoke with him since I've been here, and he said, as soon as I get out, I still have a job, so just hoping to get out soon so I can go to work. And
Okay. Well, you should be able to get out and then today or tomorrow and get back to things. You're going to want to connect with Ms. Snyder. She's going to call these different numbers you've got so you and she can figure out a time to meet, figure out what to do with your case, okay?
Okay, so you said a signature bond?
So I cannot legally set a signature bond because of a couple of the counts you have. I will make it a equivalent of a signature bond for some of the counts, but for a couple of them, I'm going to need to make it like $100 or something because it's not. Judges can't set signature bonds for certain offenses anymore. The law changed as of January 1. So I will get a bond. I'm going to get together with my staff. We'll structure it. If whatever I set it at is something that you can't make, let Ms. Snyder know, and I'll adjust the dollar amount because I think you ought to be released given the age of the 17 SC case. Your newer charges to me seem more serious, but a judge has already given you, back when you could get a signature bond, gave you a signature bond, and I'm not going to upset that decision-making process at this time. Okay.
All right, thank you, Mr. Judge McBurney.
No problem. We will we get a scheduling order and we'll figure out what we see next.
All right.
This time, before Mr. Buford goes, anything else in Mr. Buford's case?
No, sir.
Okay. All right.
And that concludes my business. May I be excused?
Maybe who's going to handle Earl Wade?
That'll be my case, Your Honor.
Oh, Ms. Patel. Okay, yes, Ms. Snyder, you're free to go.
No.
Good morning, Mr. Wade.
Morning.
How you doing?
I'm all right.
Good. Mr. Wade, you have probation revocation matter. You were sentenced in a case, a 2018 case, aggravated assault. And I've got a petition here, excuse me, that alleges that in February of this year, about a month ago, you committed the new crime of aggravated assault and possession of a firearm, and then maybe reckless conduct. My guess is those charges have not been, no, they haven't, I've got the CP number, they've not been indicted. So we need to figure out what we're gonna do with the situation. Ms. Patel, does Mr. Wade have a bond in his new case?
He does not, Your Honor.
Okay. What were you thinking we would do today in light of the fact that there's no bond on unindicted charges?
Your Honor, I spoke with Ms. Holland. We would be requesting a reset on this case, either waiting for the defendant to potentially receive a bond or have this case indicted. I did do a little research into the new case. I requested the police report, and the issue is fairly dispositive in that supposedly it was caught on surveillance camera. So I've requested that footage to see either it'll show what officers say or it'll show what my client says. Once I get it, I think I'd be able to have a conversation with Ms. Hall about whether we can move forward on it, or whether it seems like something that needs to be handled globally with the other case.
Okay. We know how much time remains on Mr. Wade's 18 SC case?
Yes, Judge. Mr. Wade has 7 years, 3 months, and 6 days remaining.
Okay. So there's a meaningful chunk of time, and if these new allegations withstand scrutiny, that makes it pretty complicated for Mr. Wade. So, Ms. Patel, do you feel like you've got a promising lead on getting the surveillance video? Sometimes that stuff can be notoriously difficult to get surveillance video.
Yes and no. The police report said that the officers did request it, but that they also recorded it on body cam. So I subpoenaed the body camera first because if they did properly record it, I don't even know if we would need the surveillance footage. They said that they did. Sometimes they don't. And then I'm going to send a second subpoena to see if they've actually retrieved the footage themselves.
Okay, got it. So what you're saying, and I guess this is a smart use of body cam, is that the officers respond to the scene and there is a way to view the surveillance footage and they record a replay of the incident, basically, on their body cam.
Correct.
Great, okay. I don't know what fidelity that will have, but it's better than nothing. So it's a start. Okay. How much time should we set this off into the future so that you can try to get this? It may be that Ms. Hall's trying to get it as well. And then more importantly, after you get it, you can have a conversation with Mr. Wade and Ms. Hall about what you want to do.
I think a month should be sufficient. So perhaps end of April, that should be enough time for APD to respond.
Okay. If Mr. Wade gets a bond in his unindicted case before then, let me know if we need to gather before then to reassess. But I think that makes sense. These are serious new allegations and they're disturbingly similar to the case he pled to. So I think keeping him where he is right now makes sense. But if something changes, I'm happy to reevaluate that. But in the meantime, it sounds like you'll be working hard to get the surveillance footage that will either undercut the allegations or support the allegations.
Yes, sir.
Okay. The bond order denying Mr. Wade a bond in the unindicted case said multiple aggravated assaults. CP cases is real hard to tell what's going on with them. Have you read a police report, or is it basically alleged that Mr. Wade shot at multiple people, or is the bond order mistaken?
I think the bond order is mistaken. The allegation is just that allegedly he pointed a gun at a security officer, and that was it.
Okay.
But there are no other alleged victims in the case.
Got it. Okay. Ms. Hall, anything you want to add to Mr. Wade's situation?
No, Your Honor.
Mr. Wade, did you follow what we've been talking about?
Yes, sir.
You got any questions?
No, sir.
All right. If there's any movement in your unindicted case, we'll get back together. Otherwise, we'll try to reconnect towards the end of April to see if we can do something with the revocation petition. Thank you, Ms. Patel.
Thank you, Judge. And Your Honor, I believe that concludes my business before the court.
I think it concludes everyone's business.
And Your Honor, there is an afternoon motion calendar that Jonathan Melnick is officially going to handle.
He is, but it's not happening. Poor Mr. Carter waits for another day. The key officer that the state needs is unavailable. So Mr. Melnick has agreed to a reset. And I appreciate his entry. Most of all, I appreciate your persistence in semi-representing Mr. Carter as he asked it about for that magic lawyer he was looking for. Hopefully he's found him.
Right. I didn't think it would happen, but it finally did. So I'm
It did. It did. So I'm anxious to have the motions hearing because Mr. Carter was a case you said we could try if we got through the motions. And this division needs to get a trial under its belt. Now that Judge Leffordge is trying one now, I'm hoping we can get in the queue as well. So, all right. Well, thank you, everyone. Today is vaccination day over at the Mercedes-Benz Stadium for district attorney people who didn't cut the line and public defenders and court personnel. I'll be going. So if vaccines are your thing, go do it.
Thank you, Judge.
All right. Thank you, Jill.